The Supreme Court was buzzing on May 15, 2025. Everyone expected fireworks. After all, the case before the court involved President Trump's controversial executive order on birthright citizenship. The order, defying the 14th Amendment, aimed to dismantle the very foundation of American citizenship. Adding to the drama, Trump's lawyer, John Sauer, was facing off against a formidable opponent, Justice Amy Coney Barrett. This was no ordinary face-off. Barrett, appointed by Trump himself, had recently faced a barrage of criticism from the conservative right. They accused her of straying from conservative principles. The tension in the courtroom was palpable. Would Barrett side with Trump? Or would she uphold the law, even if it meant defying her own camp? Justice Barrett didn't waste time. She cut to the chase. Her questions were laser-focused on the administration's commitment to following court orders. Sauer, representing the Trump administration, argued that they generally follow court rulings. The word generally hung in the air. Barrett pounced. Generally? She echoed, her voice laced with incredulity. So you're saying the administration wouldn't automatically comply with a court order, even from a circuit court? Sauer, seemingly flustered, reiterated the administration's stance. They would generally comply. Barrett pressed further, her tone sharper. Was this a long-standing policy of the Department of Justice, she wondered, or something unique to the Trump administration? Sauer maintained it was a long-standing policy. Barrett, unconvinced, honed in on immediate compliance with recent rulings. Sauer, sticking to his script, repeated, generally. The courtroom buzzed with each pointed question from Barrett. The conservative justices, known for their strict interpretation of the law, seemed surprised by her line of questioning. Barrett then brought up Cooper v. Aaron, a landmark 1958 case. This case solidified the Supreme Court's authority over lower courts. She reminded Sauer that the case established a clear precedent. Supreme Court decisions are binding. She asked Sauer if the administration held the same respect for circuit court rulings. The question hung heavy in the air. Sauer's evasiveness was palpable. He shifted focus to nationwide injunctions, a thorn in the side of the Trump administration. He argued that these injunctions, often issued by lower courts, forced the government to comply with rulings they disagreed with. Barrett, however, saw through this argument. She drew a parallel between nationwide injunctions and class action lawsuits. Both, she argued, could impose significant burdens on the government, yet they were accepted legal mechanisms. The back and forth between Barrett and Sauer wasn't just about legal technicalities. It was a microcosm of a much larger battle, the battle for the soul of American democracy. The courtroom drama exposed the fragility of judicial respect, a cornerstone of American democracy. Here was a president who openly defied court orders, and his lawyer, instead of defending the rule of law, resorted to legal loopholes and vague assurances. The case, centered on birthright citizenship, further amplified the stakes. Trump's executive order, attempting to dismantle a constitutional right, was seen by many as a blatant power grab. Barrett, with her pointed questions, emerged as an unlikely defender of the judiciary. Her scrutiny of Sauer, her insistence on upholding the law, even if it meant challenging the president who appointed her, offered a glimmer of hope. It reminded everyone present that the law, at its core, is about protecting rights, not serving political agendas.